Section 8 for financing. 8A, if that's checked off, cash transaction. Cash transaction does not mean that the buyer has to close with their own money. They could still get financing and close, but it just means that they do not have a loan approval period. There's a lot of offers happening right now where buyers are saying, let's put in a cash offer because it's a competitive market and they want to show that they have a better offer than another buyer. If they don't have the money to actually pay for it in cash, I highly advise against that. Because if they don't get a loan approval, once they go past the inspection period, they have no way out of this contract due to financing. There might be other ways out, but they're few and far in between. 8B, this is the financing section. It defaults to 30 days after the effective date with the blank there on line 87. The box is on line 86 for conventional loan, FHA, VA loan. If you have the listing and somebody's submitting an offer with a conventional loan, that might be more appetizing for the seller than it is with an FHA loan or a VA loan, because FHA loans and VA loans automatically come with appraisal contingencies. There's often questions about whether or not denying somebody or not accepting an offer because they have an FHA loan or a VA loan is discriminatory. It's not discriminatory if you're declining the offer because you don't want to have an appraisal contingency. So if you have a conventional offer, it might be more attractive than an FHA or a VA. The buyer has to make the mortgage loan application for financing within 5 days after the effective date, and they have to use good faith and diligent effort. Now I'm reading from line 91 and 92 here. The contract doesn't really state what good faith and diligent effort is, except for line 96, where it says, for the purposes of this provision, diligent effort includes, but is not limited to, timely furnishing all documents and information and paying all fees and charges requested by buyer's mortgage broker and lender in connection with the mortgage loan application. What does that mean? Let's say your buyer makes their application, but they lag and they don't give all of the information that the lender's requesting in a timely manner. They could potentially be in default. And if the seller is asking for information from the lender, you want to make sure, if you're representing the buyer, that you're on the same page with your lender. The lender doesn't have to give them any information other than the status of the loan application, the loan approval, and the loan processing, which means the application has been made or not made, and the status is they're approved or not approved yet. That's it. That's all they have to say. They don't have to give denial letters if they get denied. They don't have to say any of that stuff. So again, diligent effort. I had a situation where a buyer was backing out of the contract during the loan approval period, and their agent told them, okay, yeah, you didn't get loan approval, you got denied, you're going to get your deposit back. The listing agent asked for the denial letter. The lender sent it over to the listing agent, and the denial letter said that they were denied for not furnishing all documents. So the listing agent and the seller's attorney said, well, your buyer is in default because they didn't timely furnish all documents to the lender, and so we're owed the deposit. So it went to litigation. It was a large deposit. I think it was like $30,000, and the seller ended up winning in litigation. But then the buyer ended up suing her agent because the agent told her she was going to get her deposit back. To further hammer home this point, the agent and the broker's E&O insurance did not cover the claim against them because the insurance was stating that the agent was practicing law without a license and acting outside their scope as a realtor because they were interpreting the contract as to who was going to get the deposit back. That's a true horror story. Everything that I tell you about in here, as per examples, have actually happened. So be very, very careful with these things. You know, one of the reasons why we are able to work with a lot of agents is because we're trying to help you guys protect your license too. Don't ever be afraid to get on the phone and have one of the attorneys from our office explain something to a client so that they're hearing it from the attorney and not hearing it from you guys. You don't have to make that judgment call because you're not an attorney. Now, if we're texting you and saying, yeah, put this language in the contract, that's coming from us. That's fine. But if you're saying, oh yeah, I think this and I think that, that's where you're going to get yourself into trouble. You don't need to put your license in jeopardy. By the same token, you're going to have clients that are going to ask you for all sorts of things under the sun. Let's say it's a seller with disclosures, and they're going to say, well, I know that we had a leak upstairs, but I don't want to tell the buyer that. You have to tell the buyer that. And you need to be able to explain to your client or tell your client, no, like, I have a license to protect. And guess what? We'll just tell the buyer, this is what happened. It's been priced into the purchase price. Take it or leave it. It's as is. There's no problem with disclosing in that situation. But what you don't want to do is start making decisions about potential legal ramifications without getting the attorney involved to actually explain it to the client, because that's where you're going to get yourself into trouble. And that's what we're here for. We make ourselves available for that too. Be very, very careful of all of these things, especially when it comes to loan approval and the deadlines. You know, if you think a client in your conversations with the lender is not going to get loan approval, we may need to do a conference call with the buyer and the lender so that the buyer can make a decision as to whether or not they want to go past the loan approval period. Because once they go past the loan approval period, their deposit's in jeopardy. There's only a couple ways out after that.